Greetings, everyone. Welcome to my classroom. As promised, we are going to talk about land settlement disputes or various issues that can arise from land ownership or at least trying to reclaim what is rightfully yours. We can get very emotional about this, and I have a lot of emotional stories that I can share. But one of the reasons why I'm doing this is that we stop crying about these things and we start making better choices in our life, start taking responsibility for our own part that we have played or lack thereof. So, some of the issues that I've had in my own life, I have neglected to put myself first, prioritize my own needs. And some of it I couldn't control. For example, investing with my father and making that poor judgment. We always feel that, family is number one and that we have to do everything with family. But you know what? You have to take care of you, because even though we have the family as a unit, you are still an individual within that family. And so we're going to look at the land dispute settlement, the different types of land ownership, and important facts for you to know before you add individuals to your land title, before you purchase land with somebody, so on and so forth. So on my chalkboard over here, I'm going to just give you the topics that I'm going to deal with because I have my notes here. So first, and it might not be in any specific order. So we're going to look at crown land and what that means. Then we're looking at the types of land ownership. For example, joint tenant or tenant in common. What is the difference between these two above, joint tenant and tenant in common? In common. I don't know why I'm feeling the urge to say command. And here I have what is an escrow. I just wanted to put this here. At the end, we'll talk about that. Something that for you to know and understand when you're making some of these decisions. How to add a name to title. How to get land title in Jamaica. What is needed to add someone to house title. And we're going to look at quit claim. Transferring of title. When would or should someone add another to their title? And then we're going to look at grant deed. And if you wish, I can come back and do another video with one particular topic in mind. But this is just overall for today in this video. I'm going to sit here and I'm going to take my notes and I'm going to read from my notes. And if you have any questions, you can ask. Now, what is crown land? As the name suggests, crown belongs to the government. When you think about Jamaica, the land of Jamaica, and you go way back from when Europe decided to explore different parts of the world, Jamaica was one of the places where both Spain and England went and put their stamp and said, this is ours. That's not what we're talking about today. But when you think about crown land, you think about government-owned land, which Jamaica government doesn't really own the land. They're just supervising the land for Great Britain. So anyway, crown land, and many people in Jamaica, they're called squatters, live on crown land. And there is laws in place now that will allow some of these individuals to claim these crown lands, to get titles for these crown land. But the crown land specifically is owned by the government. And you have to live on the land for 60 years, unbroken occupation, before you can get a title for this land. You can then apply to have a title issued to you by a method called adverse possession. So you've lived on the land for over 60 years and unbroken occupation. So you've never moved off for 60 years. There's a way within the law that you can now get a title for that property. And there are different places in Jamaica where individuals are in the process are already done so to get their land. Again, we're not talking about the government in terms of attacking them for what they have done. And, I've seen videos where people talk about how the government is helping people to steal land and is selling out land to foreigners and so on. This is not what this is about. We can talk about that another day. This is to teach you how to know how to secure your interest, or if you haven't purchased land, the methods to make sure that you're not taken. So if you're occupying a premises and you're paying taxes and you're maintaining it, you have established right in the property as an adverse possessor. So if you have lived there, you've occupied it for a time, you have paid taxes, you have been maintaining this property, you now have established a right to gain possession of this land. Not just crown land, mind you. And again, to qualify for crown land, you have to be on it for 60 years. But this still applies to individuals like you and I who might have purchased land or might have inherited land, who have migrated. This is one of the big focus for this video. Individuals who have property in Jamaica and, you know, feel so comfortable and content that when they retire, they're going to go home to their property. Only to find out that there are certain laws in place, certain things that individuals within Jamaica know, and they're using their rights to claim this property, and you might find yourself in a very bad situation. So rights to such a property can be attained by cutting vegetation from the property, maintaining it, fencing it. You can farm on this property. You have settled a residence on the property. So if you own land, for example, you migrated and you left family member or a friend, someone to oversee your property, that property could eventually become that of the person you left to oversee it. If this video cuts out before the end, I'll do a part 2. So this is why you have to be very careful who you're leaving on your property, who you're, you know, thinking that they're looking out for your best interest and they're not, and how easy it is for someone to gain access of your home that you've worked very hard for or have inherited. So cutting your property, putting up fence on your property, you know, living on that resident. And a lot of time people are leaving Jamaica, they feel safer, they feel it's better to leave someone in their household, but that could become a potential problem for you later on. So if the person starts paying the taxes on the property, that means they are establishing possession of that property. And there are ways, many ways of establishing themselves as owner of that property. So let's look at the principles of adverse possession. And the adverse possession, again, is individuals who've lived on crown land for 60 years and have maintained it and have never moved off it, or other individuals who have lived on that property for 12 years if it's private, live on the property for 12 years and have been doing this, the examples that I've suggested earlier, chopping it, fencing it, living there. This principle is one under which a person in possession of land owned by another may acquire a valid title to it as long as certain requirements are met. And the requirements are as suggested earlier: maintaining it, fencing it, farming on it, establishing a living, paying taxes on that property for over 12 years. This assumes that the person taking control of the property has been in possession of the land by another person, and that person may acquire valid title to it as long as certain requirements are met. This assumes the person taking control of the property has been in possession of for a sufficient period of time as defined by Limitations of Action Act for privately owned land at least 12 years. I repeated that because I want you to hear it. Individuals can approach an attorney when they have established a right or interest in the property supported by the law. You may make a title application by means of adverse possession. And all you've got to do is make sure that you have that land surveyed. And when you get it surveyed, you're going to take what is called a pre-check plan to the National Land Agency. You have it surveyed, land that is not in yours, have it surveyed, get that pre-check. And of course, individuals would have perhaps switched title or added individuals to their title, and we're going to talk about that later on. But the action of the owner, the landowner themselves, can therefore work against them, can backfire. And let's look into that. So before we go any further, with two types of land ownership, we want to look at that. You have the joint tenant and tenant in common. Tenant in common. The first definition of tenant, what is the difference between these two? Joint tenants have a right of survivorship. That is, if A and B own land together as joint tenants, and if either A or B should pass away, then the interest of the deceased will go directly to the one that survives. So if you have your husband or a family member or a friend that you purchase land with and you're going into this deal as a joint tenant, both persons have equal access to the land as long as they're both living. If there's going to be any changes, both of them have to agree to those changes. If one should pass away, the other person who remains will have full ownership of that land. Therefore, if your father owned the land with your stepmother and your father passes away, the person who is alive, which is the partner or whomever is in that joint tenantship, that person gets full access to it. So even if your father intended for you to have property or have land or so on, you're not getting that. If I purchased the land prior to meeting my husband, and after we got married, for some reason, I put him in and we go into this as, well, I guess it wouldn't be a good example because I think with joint tenancy, the agreement has to be made at the same time. But in the cases where individuals, husband and wife, come together and buy property and one passes away, if the husband had children from a previous relationship and made agreement with those kids to give property, there's a possibility that the stepmother can take the whole property to herself. Let's continue. So that's a joint tenant. The joint tenant does not have an interest. So the joint tenant that died no longer has any interest in the land, but it's solely belonging to the surviving tenant once the other partner has passed away. The death is noted by an application to note the death of the other joint tenant. So as I said before, the husband passes away or the wife passes away, and if it was a joint tenant agreement, then the one who survives has full control of that property. This is why sometimes you hear family going and trying to attack the remaining spouse because they're saying their daddy or their mommy owned the land before and now they expect to get their part, and it doesn't work that way. The law does not support you throwing somebody off a property who has, even though it's happened, but it's because the individuals who own this land with their husband, if they're joint tenants. Now, if you're not protected on that joint tenancy, that's another story. Anyway, to create a joint tenancy, there are rules to follow. All the joint tenants must acquire their interest in the property at the same time and from the same transaction. That's why I had to switch up my conversation earlier to say, if I had the place and then I got married. No, if you're going to be a joint tenant, you would have had to purchase it together at the same time. The interest must be identical in nature, and each tenant enjoy the right to the whole or any part of the property, but not an exclusive right to possess any part. So if we purchase it together, the agreement is made at the same time. Therefore, we can't change the rules in the middle of it. We are entitled to equal access to it, but not a special possession of any particular parts. Tenant in common, on the other hand, is a tenant in common does not possess a right of survivorship. So if you enter this agreement as a tenant in common, when your partner dies, you're not left with that security. And so the interest of the land is not then passed on to you as it would have been in the joint tenancy. If he dies leaving no will, his interest is distributed under an Interstate Estate and Property Charges Act. And once a tenant in common dies, the passing of his estate to the personal representative is registered by what is called a transmission of application. So if that tenant in common passes away, you're not able to then come in and say, family members or friends can come in and say, okay, this is how this. No, the representative, the person who's left as the estate personal, I should say. the tenant in common has an undivided share and interest in the property. He or she has an equal right to the possession of whole of this property, but not a right to possess any part exclusively. So this is very similar to the other type of ownership. A tenant in common has an undivided share and interest in property. He has an equal right to the possession or whole of the property, but not a right to possess any part exclusively. So they're both together, but you can't just say, okay, this over here is mine, or this quarter acre is here. I want this at the front, I want the part at the back. They don't have that right. Tenant in common may deal with his share of property any way he wishes, as long as they're the husband and wife or the whoever owns the property together is still alive. You can do whatever while they're still alive. A tenant in common may also hold unequal shares in property, and therefore, if no share is stipulated, so again, in a situation where someone owns 20 acres of land and their relationship with someone else causes them to be in this joint common, in this common, I think it's joint common, joint tenant, and tenant in common, right? That kind of relationship. Even though only 1 acre of that land belongs to that individual, upon the death of the other person, if you're tenant in common and you had 3 acres, it could be reduced. Or if you're tenant in common and the joint tenant agreement or arrangement, you can then lose. So you had 5 acres, you joined it, you bought the property together, you bought 10 acres together, but one person deceased and you are in that position where you're just tenant in common, you can lose your share. Do you get what I'm saying? It's a little bit confusing. So you own 10 acres as the joint tenant, but the tenant in common joins you, or you added someone to the lease, the person only has 1 acre, or the person put in nothing, that person could have equal share, 50-50 at the end. There's a presumption that it's going to be 50-50. How to add a name to a title and how to get land title in Jamaica. First, you must apply to register your land and you must provide the following documents. These documents must be submitted an application form prescribed by the Registration of Title Act and signed by an applicant. A statutory declaration to prove possession, written statement confirmed by oath. So a written statement confirmed by oath and an application prescribed by the Registration of Title Act. Now, this is scary because we know wherever corruption is, and you know there are lots of corrupt people in Jamaica that will provide you with documents that are not legal. They're not legitimate documents. Authority. We've seen lawyers who are now being accused of stealing and selling people's land. They'll provide you with these documents. So it's so easy for people to come to Jamaica or those who live here, find ways around the system to make sure they uphold the law by doing other illegal things within the law, if that makes any sense to you. The question is, can you add someone to the title of your house? And this part is very scary too, because like I said, there are lawyers that will help you do this. They help you navigate the system. And because they know that someone has left for a while, or people have inherited land from their family members and they just never went back, and people just claim this land by using the same system and using corrupt lawyers to do these kind of things. So if you have property in Jamaica, be careful, be aware that folks can come in using the very law that is set there to protect you. The same law that is there to protect you is also giving people loopholes or opportunity to come and fight and beat the system. A quitclaim deed can be used to remove someone from or add someone to the title to your house or property. A quitclaim deal does not include a promise that your ownership is good or free from other claims. So this quit claim deed that you can use to add someone to your land title or to remove them is one that doesn't promise you that the ownership is good or free. So let me give you an example. A few years ago, a friend of mine went and bought a piece of property in Montego Bay. Prime real estate. It was too good to be true. The price was just really reasonable. After she purchased it, she found out that it was owned by someone else. So people started finding ways and methods they get access to, and they're getting inside help from people who work in the government. So they allow you to get title for land that is gone, sometimes without taxes being paid on it because family members are not there. And you get access to it and you add your name to it. Once this is done, it's a battle for you to go through the court system to prove that this is your land and this is not legitimate. Thousands of dollars, and sometimes people just walk away because it's not worth it. The money they're going to spend to get it fixed and to get individuals evicted from their property, the consequence is great because some people will just kill you if you try to reclaim what is yours. And so sometimes people just cut their loss and just, lose their property for one reason or the other. So this quick claim, it doesn't guarantee you to clear the title. So the only way to protect yourself when you're buying property is to make sure you do a title search and you purchase title insurance. So you buy the land, you go to the bank, you go through all the methods and whatever, you could still find yourself in big trouble once you're buying property in Jamaica because there's so much corruption going on. There's so many underhanded lawyers, so many people who know how to rob the system and how to abuse people and take what is not theirs. Before you add someone to your title, I want you to know this. If you transfer all or part of your ownership to another person, you lose control. Sometimes people do it because they trust family members or they trust their friends. And so they're saying, because I'm not there, I'm going to transfer you, add your name to my title so you can do business on my behalf. A lot of people have had regrets. A lot of people have lost their lives. A lot of these killings you hear going on in Jamaica, that's why I tell you, there's no random killing in Jamaica. It's all related to something. Sometimes individuals don't want you to move back. They want the property for themselves. And this is mostly family that does this. And they get people to bump you off for your property. When would someone add someone else to their title? Here are some examples. You're going to add your spouse because you're so much in love and you have this property and you want to just share it with your loved one, your beautiful husband or your boo, and then you decide to add them to your property. When you're selling the property or you borrow money against your home equity and you're required to amend your title to give the lender a security interest in your property. This happens a lot. So you go to the bank or you go to some broker and you ask them, I need money. And they say, well, in order for you to do that, you're going to transfer your title to them. Big mistake. You could lose your right if you had someone to your title under the following circumstances. Allowing someone to hold your deed temporarily, adding a person other than your spouse or your child can result in a higher property tax. We'll talk about that another time. But primarily, I want you to know that allowing someone else to hold your deed can cost you your property. A deed holder, even the one who holds only a percentage of the property, can take the mortgage and loans, can take out mortgage and loan on your property, tear down your house, or sell your property. Let me repeat this. A deed holder, the person who you ask to hold your deed because you trust the individual, that person can take out a mortgage on your home, take a loan, tear down your house, sell your property, and there's nothing you can do about that. A deed transfer may trigger a full payment of your mortgage. And I'm looking at it like this. Someone who has your deed could run in and finish paying off your mortgage and that house belongs to that person. Or the bank would say, well, you transfer the interest and now we want the full payment on the house. And then we're going to talk about grant deed. Grant deed immediately transfer all of your interest, your ownership and rights in the property. After signing a grant deal, you have no control over your property. And if you're living on it, you can become a tenant and can be kicked off by the new owner at any time. A grant deed contains a promise that your title and ownership is free and clear, subject to the existing claims that you disclose and lien that you disclose. You could be liable for monetary damages and could be sued by title insurance. And remember to do your title search. So even what is considered to be your best intention, crying about it afterward, and some people have committed suicide, and some people have been devastated, some people have lost their mind because they transfer their title or share their deed with someone else, asking the wrong person to hold on to their deed, and they lost everything. Warnings over here, big bold warnings. These are all warnings. About crying about these things after the fact does not help you or I. I can cry with you all I want. At the end of the day, you're not getting it back. And if you don't have thousands of dollars and years to tie this up in the system, you walk away losing everything. Do not add family or friends to title, even if you intend to give it to them upon your death. Upon your death, you plan to do this. Do not add their names to it, because they'll convince you, admit my name now so there's no problem when you die. No, this is where a will comes in. You make a will. You outline that intention in a will. Don't let folks talk to you about transferring title or adding them to the title before you pass away. Don't let anybody hold your title. Do not agree to transfer title to your property temporarily. And this is from brokers or bankers or horrible, financial gorgers or rapists. They will encourage you when you're going to get a loan to allow yourself to transfer part of your title to them. Do not do that. Do not engage in these kind of arrangements, because of the dishonesty of some brokers or lenders who will ask you to sign a ground deed, and he and she can hold that. Do not do it. There's nothing to stop that individual from selling the property. Or at this point, you can't force anyone to transfer that property back to you. So if you choose to take out a loan on property, insist on what we call the escrow. And the escrow, let me give a definition for that quickly. It's a bond or a deed or other documents kept in the custody of a third party, taking effect only when a specific condition is met or fulfilled. So if you decide that you want to go ahead and you want to take a loan out on your property, make sure you have an escrow in place. Hope this was not too long. If you want me to talk about this specific example of what happened to me, I grew up with my aunt and my sister, and I had another sister that she also raised with acres of property, acres of land, where I assumed the relationship I had with my sisters, that there was no dispute as to if I would get a little piece of land here or there. It was just understood that we would just share the property. But they kept me out of it. They kept me complete out of it. And one of the things that I realize now, when I used to ask my sister to check out the taxes so I could help her pay it, she used to make all kinds of excuses. She didn't have time. Even if I volunteered to give her the money to go and take care of it, she didn't have time, because she fully intended, a girl that I grew up with from the time I was 6 years old, and the mother who raised me, even though she was not my biological mother, but raised me, the very clothes that she was buried in, I bought that. I helped to bury her. And while I was here in this country, I used to go home every 2 or 3 years to go see her, see her husband, who was like a father to me. And I was there for them as a daughter. I loved them as a daughter. Even if they, didn't give me all the love I could say 100%, they were the parents I knew. And when they died, I made sure I take care of my aunt. I made sure that she was ever present in my life. And when she passed away and I went to visit, I couldn't pick an orange from the tree. I was picking an orange from one of the trees. I got my nephew to pick the orange, and the reason why I was doing that is because I wanted to get the oranges to sell them to make some money to do some work, some charitable work or charity work at the school, because their kids were going to school hungry. And I took the oranges that were falling off the tree, because it's acres of land, oranges falling on the ground, and I decided to pick them up and pick some and sell them and use the money to do a breakfast program at the high school. So kids could come and get breakfast in the morning. And I did it, sold them, got the money, added my own money to it, started my breakfast program. And one morning I asked my husband to pick some more oranges again off this abundant tree that nobody wanted, nobody was using. And my sister sent her son to, every time he dropped the oranges on the ground, he chopped them and threw them away. And when I asked, who can stop me from picking oranges off my property, she asked me, who is paying the taxes? My mother. From the time I was 5 years old, I was living with this woman, and she passed away. And like I said, the very clothes she was buried in, I bought it. I was the one who spent $2,000 in airfare alone just to go to her funeral and to participate in burying her. And the acres of land, I never got not even an orange tree. Because what? She didn't leave a will. And I don't know how the land was bought, if it was a joint tenant situation or it was a tenant in common. Whatever the story is, it doesn't really matter. My sister took it all to herself. And the other sister, not a nice person, not a nice human being to say, give her something so she can be reminded of her relationship with her mother, the only mother I knew. So I know what I'm talking about this, but I'm not going to just cry about this today. I just want you to know your rights. Know your rights. Understand your rights. And know that there's some wicked sharks in the world who will rob you of your birthright. And land is how they do it in Jamaica. They will come to a home that you've worked hard and build, as is my case with my father. You know, individuals now waiting for him to die so that they can take his house. But that's not going to happen, because in that case, I'm going to use the law and I'm going to reclaim what is mine, at least the money that I put in. And they can't pay me all of it, but they will not sell that house, because I'm going to take steps to make sure that house is not sold until I get what is mine. So be forewarned. Be smart about what you're doing. Otherwise, you're going to just be crying, you're going to be bitter, or you're going to subject yourself to being killed by individuals who encourage you to buy your land and get them to come on it, or they find ways around the system to go and add themselves to your property and shut you out. Remember what I said, that you can be kicked off your own property. You can become a tenant in your own property. Stay blessed, everybody.